And in all of my years of public life, I have never obstructed justice. And I think, too, that I can say that in my years of public life, that I welcome this kind of examination, because people have got to know whether or not their president is a crook. Well, I'm not a crook.
One of the greatest lines of all time. Well, it turned out, of course, he was a crook. And now he's back in the news. Poor Tricky Dick. Now, the lawyers for Bill Baroni, that's the former Port Authority official indicted for Bridgegate, they want Chris Christie's email and phone records released. Former Deputy Chief of Staff Bridget Kelly's attorneys, they're also requesting them, but Christie's attorneys, they're holding back. And that's got Baroni's defense team comparing this to President Nixon refusing to release the Nixon tapes. They filed a brief that says, in part, President Nixon's tapes were not immune from a subpoena, and neither is Governor Christie's phone. In the meantime, a federal judge just ruled the trials for Baroni and Kelly will in fact proceed. They filed a motion to dismiss. The judge said, N.O. Are we going to see what was on Christie's phone? What do you think?
I think the court's going to require him to turn them over. Yep. Absolutely, because it goes to their defense. So I don't see what legal grounds Christie has to basically withhold the documents.
What's he going to say? Deliberative privilege or executive privilege or something like that? Is that what he's going to say?
Probably.
And that's what Nixon did.
The best
right?
he'll get is a review in camera by the court. The court will decide whether it's relevant to the defense. But I agree with Bill entirely. They're going to be produced, and this just might be a stalling tactic to listen to them and look at them.
But I will say this: but looking forward, if Christie does not give up this fight and he continues to resist turning over these things, should Trump get elected and should he have any nomination for a cabinet position to Christie, Christie's going to have a hard time getting confirmed by the Senate.
It's like we were talking about spoliation and an adverse inference charge. The failure to turn them over and the fighting so hard to not turn them over is going to produce that kind of inference in the public's mind.
If God forbid for this guy, there is something on the phone, should he take Mayo's advice? Put it on the driveway and back over it 20 times?
I think Mayo left. Mayo's on his way to New Jersey right now.
It's quicker to get indicted for that than anything he said on the tapes.
That's right.
You know, that's
Mayo's going to put his telephone number on a crawler across, so in case Christie's watching, he knows who to call.
Let's say he doesn't turn it over. Say he lost it, or say whatever he's going to say that he doesn't have.
If he gets ordered to turn him over, he's going to turn him over.
He's going to. They're there.
But what's the worst thing that can happen if he says, I lost it?
No, it'd be held in. Well, there'll be a hearing as to whether he lost them, whether they exist or not, and
whether he destroyed them.
Held in contempt, and he could get charged with obstruction of justice if he's not truthful.
If ordered to, he's going to appeal it, and it's going to drag this thing out.
Oh, I don't think he has though a right to appeal it now, unless he claims executive privilege. That would probably give him a right to appeal it now.
You know, I'll show my ignorance, and this is more of a technical question, but I think, and I think most of the viewing public assumes, forgetting the verbal conversations on the phone. If you send an email or a text, isn't there like a fingerprint period that doesn't go away? So even if he doesn't turn over the phone, won't they be able to, in effect, go to the servers, whether he likes it or not? Or are we overestimating how much stuff is retained?
Well, it's an interesting thing, because let's say there were text messages back and forth that they want released. Phone companies only preserve the actual text messages for a short period of time. Right. And so what you can subpoena from the telephone company are the fact that there were text messages, let's say between Mark and I, just his number to my number. But the telephone companies will not turn over the substance of the text, even if they still have them, because under the federal statute, they can't do it unless Mark, let's say I'm trying to get Mark's text messages, he has to consent.
But Bill, my question though is, you did say they keep them from a certain period of time.
Very short period of time. Verizon, I think, is like 30 days and they're gone.
But is that a byproduct of, if you're any telecommunications company, you only want to keep them for a short period of time because of exposure issues, or because there's a retention issue because you need servers the size of Rhode Island to keep it?
Yeah, it's the latter. I mean, I think the telephone companies, I don't think they're complicit in any cover-up here. I mean, the telephone companies can't retain this stuff forever.
But emails will be there.
Yeah, they'll
emails
be.
will.
I mean, I'm sure they have, unless he's using a ghost server like they say that Hillary's doing, which would be pretty ironic.
It's shocking, Mark, that you got that in. Go ahead, yeah.
No, it would be ironic against the Republicans if he were doing the same thing, which is entirely, conducting state business on a private email server. But there's going to be state open records and document laws that require the state to retain these things if he's acting as an official
And remember,
capacity.
texts and emails, they're not just yours to delete. I mean, if these people can focus on to whom the emails and texts were sent, you can go to the recipient of them and get and try to get them. I mean,
Or you can also go to AOL or Yahoo, and you can subpoena the emails from them as well.
But the conduct is not necessarily as nefarious as it seems. You know, he's not going to just voluntarily turn something over. He has lawyers, and they want the court to make a decision, and he'll turn them over. When they turn them over, there could be a whole lot of nothing there.
The only reason people care about this anymore is his association with Trump. The Bridgegate thing already did him.
Oh, I don't know about that, Mark. People haven't satisfactorily got the answers.
They can't stand him, and he's out the door. I mean, if he doesn't latch on with Trump, what's next for the guy?
But to Doug's point,
private.
But to Doug's point, from a political point of view, I mean, why stand on ceremony and resist it and challenge whether you should have to turn them over? Just give it to them.
Yeah,
I mean, why?
Because regardless of what's in them, there'll be something made of it. Regardless if it has something to do with this, a budget concern.
But if he turns it over, we're not having this discussion.
You're right.
The other thing
Politically,
is, though,
right.
But the other thing is, when you give over your phone, you're not just limiting it to these emails. There may be a host of other things on that phone that you don't want to talk about.
To that point, right? Because you can make an argument that there could be a chilling consequence if an executive turns over a phone and there's private conversations for policy unrelated. Can't you have an independent arbiter go through it and say, nothing to see here? This is what we
spoke about. The court will do it in chambers. Nobody will know about it. He's going to claim executive privilege, and he'll have to turn over the materials. The court will inspect, redact, take out what's privileged, and order the...
the subpoenas need to be specific. Subpoenas cannot be overbroad. They can't just ask for every email, and it's got to be, they've subpoenaed emails which pertain to a certain subject.
Yep.
So, except the issue is you still got to get to those emails, so you're going to see everything else on the way there.
We've talked about this next one, guys. Sometimes a case really is black and white. People can get excluded from juries just because of the color of their skin, and that can disproportionately hurt, let's say, a black defendant. Now, meet the judge who wants to end the racial bias when it comes to jury selection. That conversation after this.